But I think it's important to focus on exactly what is the basis for deporting him. If it is his advocacy for Palestinian rights, if it is his advocacy for what Hamas had done, if it is his criticism of Israel and Zionism, that can't be a basis for deporting him.
If we can begin with a topic that is on the news constantly, that's on a lot of people's minds. Some people think it's a watershed. Some people think it's more complicated than is being described. There are some complicating issues. Not all the facts, I think, are perfectly clear. But I'm talking about the case of Mahmoud Khalil. Columbia student, not clear if he's still a Columbia student, at least from what I can read. I think he finished his coursework, has not yet received his diploma. I guess the first question is either Joyce or Erwin. Can we just set the stage? Who is he and what did he do before we get to how he's being treated?
He was a Columbia student. He was one of the leaders of the pro-Palestinian demonstrations at Columbia. He's alleged to have said some very inflammatory things with regard to Zionism in Israel. He was apprehended by ICE officials, initially taken to New York and then moved to Louisiana. President Trump, after he was apprehended, said it was because of his advocacy, and Secretary of State Rubio echoed that, and there is a matter that's pending in federal court in front of federal Judge Jesse Furman.
What is or was or has been his immigration status?
He has a green card. He's married to a United States citizen who was pregnant at the time.
Okay. So what is the purported basis on which he has been taken into custody? The name of the law, and I can read it once you've identified it.
Well, what they're saying is that he was, through his speech, supporting a terrorist organization, Hamas, and also that through his speech was acting in a manner that was harmful to the foreign policy of the United States.
So this is a statute, and Joyce, I want to bring you in also, of course, that is not invoked very often, at least to my knowledge. Quote, an alien, and query whether he qualifies as an alien whose presence or activities in the United States, the Secretary of State, that's Marco Rubio, has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States, is deportable. How do we assess his treatment under this statutory provision?
So I'm so interested to get Erwin, and it's hard for me to call you Erwin, but I'm going to try. I'm interested to get your thoughts on this because the context, I think, Preet, where you and I saw this very rarely come into play was if you had someone who had been criminally charged with material support of terrorism. Usually the prosecution preceded the deportation, but technically the person who is charged or who is strongly believed to have committed that crime does become deportable. In my experience, which is, I think limited. I was in North Alabama, so maybe your experience is different. It did not involve speech. It involved conduct. It involved actual support for terrorism. That makes this case very surprising to me.
But that, before you go, Erwin, the statute I just read, am I correct, is a duly enacted statute, does not require the commission of a crime, right?
Right. It does not, but I'm just saying the context in which this provision is usually applied. Right. And as lawyers, that's what we think about. We think about what's the usual framework for application of this, because if Khalil has been singled out for very unusual treatment, then in my mind, that raises a lot of questions.
This statute, of course, like all federal statutes, has to be used in a constitutional manner. And what we haven't said yet is that the United States Supreme Court has been clear that all in the United States, citizen and non-citizen, have First Amendment rights. In fact, 80 years ago, the Supreme Court, in a case called Bridges versus Wixon, that involved the famous labor activist Harry Bridges, explicitly said that those who are non-citizens are protected by the First Amendment. All Khalil is being deported for is his speech that's protected by the First Amendment. Using the statute in this way is unconstitutional.
Isn't there also a safe harbor provision in the very statute, incorporated by reference, as I understand it, that if you're inadmissible or deportable, if that's because of the alien's past, current, or expected beliefs, statements, or associations, if such beliefs, statements, or associations would be lawful within the United States, then you can't do so unless the Secretary of State personally determines that the alien's presence would compromise a compelling United States foreign policy interest. So am I right that there's a stronger test within the statute itself if the basis for removal is First Amendment speech?
I wouldn't say it's a stronger test than the First Amendment. I would say it's a parallel test to the First Amendment. Because here you'd have a statute that since it's speech protected by the First Amendment, under the law, he can't be deported. And in addition, you have a First Amendment argument that says if it's speech protected by the First Amendment, you can't punish somebody by deporting them, even though they're a non-citizen.
Is the statute that I first quoted from, is that a valid and constitutional statute?
On its face, it's constitutional. The question is, as applied, is it unconstitutional? And so I'll go to what Joyce said. If somebody is engaged in criminal conduct that's not constitutionally protected, this statute can be used as a basis for deporting them. But if all they've done is engage in speech protected by the First Amendment, then as applied, the law wouldn't be constitutional.
So can we back up to a practice point that I think puts this into focus for me? I'm curious how y'all react to it. There's this early fact pattern in this case where when Mr. Khalil and his wife are confronted in their apartment, originally he's told by ICE agents that his student visa is being revoked, right? And that appears to be the basis for the government's preparation for these deportation proceedings. They're advised that he's a green card holder. Apparently, there's some surprise about that, and they say, well, we're revoking that too. How do you think that fact pattern ends up playing into this legal analysis?
I think it's a context that shows the government's action was improper to start with. But ultimately, what the court's going to have to decide is if the government wants to deport him now, is it consistent with the statute, and would deporting him violate the First Amendment?
Can I ask a definitional question, Erwin? The statute I read referred to "quote unquote" alien. Not a lot of people. A lot of people don't like that term. It is a statutory term. Congress has approved it, and it's in the law books. What is the definition of that? And is a green card holder, legal permanent resident, considered an alien under the statute?
Generally, the word alien has been used in federal law and by the Supreme Court to refer to non-citizens. And that would include non-citizens who are green card holders, non-citizens who are visiting the United States, those who are non-citizens who are undocumented. It would fit within that statutory definition. But of course, then there's the rest of the statute we're talking about, which seems so problematic here.
Yeah. Can I ask another question, just so we have our parameters straight? This is a case about deporting someone who's a legal permanent resident, green card holder, who is already here. If someone like Mahmoud Khalil had the viewpoints that he had, said the things that he has said from outside the United States, didn't have legal status here, and sought to come here on any kind of visa, would there be anything wrong or inappropriate or unlawful or unconstitutional about preventing his entry based on that conduct?
There would be nothing that would violate the Constitution in keeping him out. There would be a statutory provision that would be problematic. In terms of the Constitution, the Supreme Court has said the First Amendment protects only speech within the United States. If it's speech from outside the United States, then it wasn't constitutionally protected. And the Supreme Court has given the government very broad constitutional authority to determine who gets to come into the United States. On the other hand, the statutory provision you read would make it difficult to exclude somebody solely because of their speech.
So what is the showing that has to be made by Marco Rubio, or whoever the Secretary of State is, given that statute that I read, which is important to set the stage with? Is the court and is the country supposed to defer completely and totally to the Secretary of State? What are the limitations on that?
That's what the Secretary of State and the President are saying, but such deference is inconsistent with the Constitution. Let me start again with the statute. It will require that the government meet its burden by clear and convincing evidence. So it's not as high a standard as in a criminal case where it has to be proved beyond a reasonable doubt, but it's more than the usual civil case where just has to be proven is more likely than not. They're going to have to meet that statutory burden. But then there's the much more important constitutional question. Is there a basis for deporting him other than his speech? If not, then under longstanding Supreme Court precedent, this would be unconstitutional.
So there is a range of behavior that we could conjure up that is beyond speech, but beneath criminal conduct. He could be advocating for Hamas in a particular way, or providing some kind of support for Hamas that may not be enough of a foundation for a criminal case. I'm just theorizing here. But that could be enough under the statute beyond speech. And is it possible that the government has such information that we don't know about yet?
Of course it's possible. We don't know what we don't know. But I think it's important to focus on exactly what is the basis for deporting him. If it is his advocacy for Palestinian rights, if it is his advocacy for what Hamas had done, if it is his criticism of Israel and Zionism, that can't be a basis for deporting him. On the other hand, if he did other things that would be regarded as material support for a terrorist organization, then that could be a basis for deporting him. Imagine that he gave money to Hamas. Imagine even that he advised Hamas on what to do. The Supreme Court in a case called Humanitarian Law Project versus Holder said that that could constitute material support for a terrorist organization. It would not be protected by the First Amendment. And then there could be other things that he did that would be criminal, that could be a basis for deporting him. So you're absolutely right. It all depends on what is the government's justification. I would just point to what President Trump said, what Secretary of State Rubio said. It was because of his advocacy for Palestinian rights, his support for Hamas in his speech, and his criticism of Israel.
Hey folks, never miss an episode of Stay Tuned. Hit that subscribe button now. If you'd like to hear the rest of our discussion with Erwin Chemerinsky and support our work, consider becoming an insider. You'll get exclusive access to my weekly audio podcast with Joyce Vance, where we break down the biggest legal and political stories and other membership benefits. Head to cafe.com/insider to learn more and to join. That's cafe.com/insider.